Brought to you by MuleSoft, provider of the industry-leading Anypoint platform for APIs.
First, as many of you know, a few weeks back, the appellate court ruled in a case of Oracle versus Google, essentially that APIs are copyrightable. That was the takeaway, that was the big headline, and a lot of people probably only focused on the headline and said, okay, well that's it, decision's been made, whether it's good or bad or whether they differed with that opinion, it's a decision, and maybe are thinking about what their next move is. I decided that it would be best for us to scramble this panel together to really dive into not only, well, whether API should be copyrightable or not, we can talk about that for a little bit, but also what happens next? Because a lot of people are not familiar with the machinations of legal proceedings and how the court system works now that a decision has been rendered at the appellate court level. Actually, part of this is being remanded back to the circuit court. We'll talk about that process. And we'll put that in a sort of a context of, well, what should you be doing next? If you're an API provider or a stakeholder, well, what's your next action item? Should you be thinking about protecting yourself in some way? Should you be thinking about going on the offensive? We'll talk about all of those options. And we have a great panel of experts to help us sort through those options. And I want to start by introducing all of them. So way off to my right is Annette Hurst. She's a partner at Oric, and Oric is outside counsel to Oracle in this case at the appellate court level. So Annette's been directly involved in the legal proceedings that led up to the decision a few weeks back. We've got Larry Rosen sitting next to her. Now Larry, for those of you who don't know him, basically wrote the book on open source licensing. So all the different open source licenses out there, the regime that is the open source initiative, Larry is the guy that knows all there is to know about open source licensing, and he's with Rosenlaw and Einschlag. And then we have Pam Samuelson sitting next to Larry. Pam is a distinguished professor at UC Berkeley, and she wrote one of the amicus briefs in the case on behalf of intellectual property professors. And of course, well, I don't want to say of course, but that amicus brief was in favor of not copywriting APIs. And Mike Linksvayer, who's a senior fellow at Creative Commons. And one of the reasons that I've got some representation from both the open source community and the Creative Commons community is, well, okay, if APIs are copyrightable, what next? Do you use Creative Commons? Do you use a commons of some sort? Do you do you use open source? Do you not do either of those things? So we'll have a very vibrant conversation. As we go through this, if you have questions, I ask that you, write those questions down, keep them handy, because we'll have an opportunity to ask those questions. So we'll dive right into the big elephant in the room and start that off. Should APIs be copyrightable? And I'll just ask each of our panelists to address that question. We'll start off with you, Annette, since we know that your answer is yes, but we'll ask you why.
Well, so I want to stop there for a moment and say API can mean a lot of things. And it's quite clear that software is copyrightable, and that the Copyright Act has a very broad definition of software. And that everyone in this room who writes software and hopes to be rewarded for that effort should believe that software is copyrightable. In the Oracle v. Google case, the code that is at issue. Oops. Did you turn me off? There we go. Already? In the Oracle v. Google case, the code that is at issue cannot be distinguished from other kinds of code that we think should be, and absolutely must be copyrightable in order for our economy to continue having as one of its major economic engines software. And so I'm here to say the rules for copyrightability are no different for whatever you might call an API than they are for any other kind of work that is subject to copyright. So for example, in music, we don't say there's a category of music that is uncopyrightable per se. We don't decide, oops, waltzes, 1, 2, 3 beat, not copyrightable. We don't look at poetry and say, haiku, 575, oh, not copyrightable. We don't look at art and say abstract expressionism. That's pretty basic, not copyrightable. Instead, there's a set of rules that applies across the board. And when you apply that set of rules fairly, in this case, what you found was, one, everybody agreed that it was creative and expressive. Even Google and its witnesses and its experts agreed. The APIs at issue here were creative and expressive. And then you look and see, you ask the question, at the time they were made, was that the only way to do it? And everybody agreed again. The answer to that question is no. That means it's copyrightable. And you all want it to be copyrightable because of the work that you're doing that you may need to protect as well. So I'm here to say the same rules should apply to something that might be called an API. That's a very broad term. It can mean a lot of things. The same rules should apply to APIs that apply to any other kind of software. There's no magic line to be drawn there. And that's the way you should want it in order to make sure that you get rewarded for your work.
Larry?
Yeah, I think the problem in this case stems from the fact that the court didn't understand, and maybe it's because the attorneys didn't explain to the court what an API really is. An API, they said at the second line of the decision, the parties have often referred to these groups of computer programs individually or collectively as application programming interfaces, or API. Well, if you go to the real authority on what an API is, which is Wikipedia, and you will discover that an API is a specification. It's not code. Now, it may be that in order to write the specification, you have to put code in it. For example, the specification for HTML5, which comes out of W3C, has code embedded in the spec. But it is still a specification, and therefore, how it is to be used is not as an expression, but as a function. That's what its intention is. More to the point, Oracle and Google both understand this. They have been working in W3C and Oasis and IETF, and at least one of them working with me in the Open Web Foundation, to try to make sure that even though in some sense it is copyrightable, it also is usable and intended to be used, and specifically intended to be an industry standard. We're not just talking about Java because it's a cup of coffee. We're talking about Java because it is a language that is specified to operate in a particular way. And as such, the requirements for it and the copyright attitudes toward it have to change. Let me give you an example of an earlier court case, not directly on point, but similar. About 12 years ago, the Veek case came out in the Fifth Circuit. It went to a decision by the Fifth Circuit, then it went to an en banc decision, and then it went up to the Supreme Court, which refused to hear it. And the Veek case related to the licensing or the use of copyrightable building codes. Now, everyone understands if you want to build a house in the United States, you better honor the building codes, or you won't get permission to build it. So the question came up, is it copyrightable or not? And the answer is, according to the court, yes, it's copyrightable, we don't care. But with respect to its use as a building code, it loses its copyright. And I think that's what we've got to teach the court about. And then when we come back, I'm going to say something more about the fair use argument, because I think the fair use argument, which the court said we need to deal with, when you look at fair use for a specification, there is no question in my mind but that Google and the rest of the world is making fair use of the Java specifications.
I'm going to get to respond to some of this, right?
You sure are, yeah. And so, and I'll just point out that the case was, a part of the case was remanded back to the circuit court on the issue of fair use. And we're talking about is basically defining what fair use is in the context of an API. And that's a big question because some of us, like a journalist, knows what fair use is in terms of text that you put into, that you take from like the New York Times and put into your own article. But in the case of an API, where that could be just one line of code, I'm just not clear on what fair use could possibly be. Larry, I just want to, one thing about open source and APIs, there are several API organizations in the industry, OpenStack being one of them, that say our APIs are open source. Doesn't that automatically imply that the APIs are copyrightable?
I'm not going to argue
since open source is a copyright regime?
I'm not going to argue with the court. I think they were probably right in saying that the original work that was done by Oracle or by Sun in developing the specifications, writing them down, they, as you said, they had thousands of choices of how they could do it. They picked some particular choices. At that point, it was copyrightable as far as I wasn't angry, but
I'm so glad we can agree on that. I knew
we can agree on, but that doesn't mean that you have a copyright for all purposes or for all times. It has to do with what you say, and the fact is that Sun and then Oracle have for years licensed, released, developed the Java community process, which according to Sun and Oracle's own industry experts that I work with every day, they insist that those kinds of specifications have to be available for the implementation of open source software. Now, it isn't clear that the licenses are written right to do that, and that's why we set up the Open Web Foundation. But I don't want to go too far off with what kind of licenses you should use, but I would suggest that Oracle and Sun have for years given us a license to Java and its APIs. And for them at this point to make a claim about the copyrightability of header files is, I think, a little bit outrageous.
Okay. I'm going to come over to Pam. The reason I'm waiting is so, because you want an opportunity to respond, but let's get everybody here so you can respond in aggregate. And again, I don't want to spend too much time on the copyrightability question because there's so much more to cover here. So Pam?
So computer programs aren't like poems. They're not like music. They have a functionality that makes copyright a particularly strange law to be applied to them. So nobody these days would argue that software isn't copyrightable. For sure it is. It protects code. It protects possibly some structure, sequence, and organization of programs. But that term, structure, sequence, and organization, which comes up in the context of the API copyrightability in this case, has been discredited as a kind of a way of thinking about what copyright protects in computer programs, because it doesn't help you to distinguish between structure that really copyright should apply to and functionality which it should not apply to. So there is a provision in US copyright law that says that you can't get copyright protection for a process, procedure, system, or method of operation. And a big question that's issue in this case is what those words mean. And it's important to understand that Congress put those words in the statute specifically so that the scope of copyright protection in computer programs would not be too broad. And there have been a number of decisions interpreting what 102B process, procedures, system, method of operation means in the context of software. And two of the decisions of the Ninth Circuit Court of Appeals, which is the Court of Appeals here in California and on the West Coast, says that the functional requirements for achieving compatibility which we all understand to be APIs, are part of what's unprotectable by copyright law under this provision. And it's been settled law since 1992 that the functional requirements for achieving compatibility are beyond the scope of copyright protection that is available to programs. And this case essentially takes us back to the mid-1980s when the copyrightability of APIs had seemed to be a plausible interpretation of the statute, but then both the Second Circuit Court of Appeals in the East and also the Ninth Circuit out here in the West basically said no. So I think not only did Judge O'Malley, who wrote this Oracle decision, not know what an API is, she don't know copyright law either, and so this is the worst decision out of a federal appellate court since the Whalen versus Jassel case in 1986, and that's saying something.
I just want to say, I would rather you tell us what you really think, if that's okay.
No kidding.
Okay, Mike?
So I'm not going to talk directly about the case. I'm more interested in what we should do from here. And to make clear, Creative Commons offers licenses like open source that operate in the same way as open source licenses. They grant permission in advance around things that copyright restricts by default. Even though those are the tools that we offer, and so therefore copyright makes us necessary in a way, we think that licenses can't accomplish everything, that user rights and innovation and competition require a big default space for public domain and other exceptions and limitations are default. So Creative Commons supports copyright reform and increasing the default regime of public domain. And in the space of APIs, although this isn't really Creative Commons' main area, that would mean that, for instance, independent implementations of an API should never require permission from the creator, the designer of the API, or previous implementers, or other people who happen to acquire the rights. I think it's really important to understand what the different sorts of things that an API consists of, both in order to answer that kind of copyrightable question that has been discussed, as well as what kind of private solutions can be applied, whether public licenses or standard body regimes. And so, I mean, those things include the actual specification text, implementation, client implementation, a server implementation, documentation. If you want to get broader in thinking about how an API comments can be created, then go beyond that and think about the data that's provided through the API, metadata about the API, for example, API registries. All of those things are things that copyright and/or patent may or may not apply to, and we can think about the right instruments to create a permission-free space that's necessary for competition. I would encourage this community to think about really creating a permission-free space for innovation. The alternative is really inviting later regulation that's much more messy in order to protect consumers from anti-competitive behavior, basically. And finally, I want to challenge the statements that without copyright, the software economy as we know it would go away and you should all be for strong copyright for software. That's just not true. And that's very evidenced in the API space, which is largely about providing services. And trade secret is still very pertinent. So it's just not true that strong copyright is necessary for, especially for software in general, but especially this community and economy to thrive. You should be very suspect of regimes that are fundamentally protectionist, are going to wreck the competitiveness of the industry and, again, make other kinds of regulation come down the pike.
Okay, so you asked for an opportunity to respond. I'm going to give that to you, and I'm also going to ask you that when you're responding to talk a little bit about how, you know, Oracle obviously contested this very vociferously and how it has prevailed at the appellate court level. What risk was mitigated as a result of this, or what, you know, why was this in Oracle's best interest?
So let me say this. I represent a lot of parties and a lot of different copyright litigation, and so I want to say that the views expressed here this morning are my own personal views. Nonetheless, they are very strongly held. What was at risk in this case was open source as you know it, and the ability to have a Creative Commons or an open source regime. Because without copyright, you cannot enforce your choice to make something open. You cannot enforce others granting back their participation in that open source framework of any kind without copyright. So if you want open source, you must have copyright or you will have no way to enforce it. What was at stake in this case was the fundamental principle on which the Java platform was created and for which it was so revolutionary. Write once, run anywhere. Write once, run anywhere. Do programs that were written for Android run on the Java virtual machine? No, they do not. Larry said, this has always been made freely available with licensing. It was made freely available with licensing on the same terms to Google. They didn't want compatibility. They wanted to fork the code and make it proprietary. They didn't want it to be interoperable, and it's not. Google perceived an existential threat in the mobile space, and it moved rapidly and with dispatch to address that threat. It copied 7,000 lines of API code, it copied other code, and it released a product that didn't meet the licensing terms upon which the Java platform had always been made available. So what was at stake and what is at stake today is the very notion that you can have a choice about open source and be able to enforce it. Because without copyright, you can't do that. And I would just like to say a little bit in response to Professor Samuelson's characterization of the law. What Oracle did when it sued Google was no different than what Sun did when it sued Microsoft in 1997, because Windows 98 and IE4 did not meet those same compatibility requirements. Sun sued Microsoft for exactly the same reason that Oracle later sued Google. If you were around then and you remember how you felt about that, you were on Sun's side. Professor Samuelson is right, we've gone back, but we've gone back even further in time. We've gone back to the original 1980 enactment of copyrightability of software. That was a decision Congress made. And Professor Samuelson and those who promote the view that APIs and other forms of software are not copyrightable are trying to undo a decision that Congress has made that has caused this industry to flourish. The Ninth Circuit never ruled that APIs weren't copyrightable. The Ninth Circuit never ruled that structure, sequence, and organization isn't copyrightable. To the contrary, software is treated the same way that other literary works are. And if you think about it, the detailed plot of a novel is something that you can't just steal and write a new novel. And that's really what we're talking about, is the detailed plot of a novel in code. Now, functionality. I brought a prop. Can you see the prop? I'm going to stand up. It's a lamp. The very famous Supreme Court case about a lamp like this called Mazer versus Stein, in which the court said that you cannot protect the function of this lamp with copyright. You can't get a monopoly on having a brass lamp with a base and a spindle and a socket. But you can protect the particular expression of the base of this lamp. That is separable from its function. And the same is true of the APIs that were at issue here. Something can be both expressive and functional at the same time. And the limitation on copyright means you don't get a monopoly to, for example, have a method of opening a secure socket connection. You don't get a monopoly on a general method. That's for patent law. But you do get your particular way of doing it, your particular expression. And in fact, these APIs were highly expressive. That's why they're so great. That's why everybody loves them so much, because so much extraordinary care and thought and expression was put into it, because they're intuitive to use. And that is the essence of expressiveness, not function.
Everybody's chomping the bit. I just want to say, wait, Larry, I'm going to let you go, but then we're going to move on because we've got. I think you'll be able to get to make your points. We have so much other ground to cover about what other procedural stuff. You'll get a chance to make your points, probably in the context of the answers that you provide to other questions.
I'll be fast.
Okay.
First of all, I want to point out that the socket into which the light is screwed into that lamp is an API. It's not the function of the design. We don't give a damn what that thing looks like. We only care that we can screw a light in it, and it's a light that can be made by any manufacturer, and it will work in that lamp. That's the difference between an API and a design. I also want to point out that Oracle is a very big company, and they have people with different ideas in it. So the views that may be expressed may be Larry Ellison's, but not necessarily everyone. So, for example, within Oracle,
let's not sink to ad hominem attack.
I'm not going to go ad hominem, but within Oracle, there was a discussion related to what was going on in W3C about the license that W3C should use for its specifications. And the option that we chose, that was supported by virtually every member of the committee, was that the specification itself was going to be copyrighted, and no one was going to be allowed to copy the specification as a specification. But in order for open source to be able to implement every W3C specification, it was essential that the license says not only can you implement it, but you can fork it. You can do with an open source license with this specification what you can do with any open source software. Meaning if you don't like the spec, write your own software, but you better not write your own spec. Or if you do, you better not copy the spec as a spec. That's the difference. And it is a subtle but extremely important difference with respect to APIs.
Okay. On that note,
it's fine.
Yeah, I want to move on because we just have so much ground to cover. We could spend 2-3 hours on this, and I don't want it. And I don't want it to turn into a big fight up here on stage, bloodbath. Let's talk about what the legal proceedings are next. Okay, so the appellate court remanded the fair use issue back to the circuit court, the district court. I'm sorry. And so that issue is going back to the district court. There's also the chance of an en banc proceeding. There's all sorts of things can happen next. So
maybe Professor Samuelson.
Yes.
Would like to.
So Pam, maybe you could just tell us legally
here's what the options are. So one option is the Oracle v. Google decision was rendered by 3 judges. There are a larger number of judges on that particular court of appeals than those 3 people. So one of the things you can do is you can ask the court.
You being Oracle, I mean Google. Google would ask.
Google could ask the full court to hear the case again, and then if that was granted, then there would be a new round of briefs and a new argument set, and ultimately some decision coming out of the full Court of Appeals in response to this. So that's one possibility.
And when could that happen? What's the time frame for something like that?
So it would happen sometime this summer, probably. The timing issues are partly set by the courts, but sometimes parties ask for an extra period of time to decide things. So I don't know what the timing is on that. Actually, Annette probably knows more than I do on that specific thing. But that's one of the options. Another option is actually to ask the U.S. Supreme Court to hear an appeal from the 3-judge ruling.
I just want to do these two options you're discussing come before it goes back to, like, what's the order of?
You can, it's one of those things where you can go back to the trial court, do the fair use issue, but I think that you can ask for the en banc review, ask for the Supreme Court, and then whatever the Supreme Court decides is likely to go back to the lower court unless the Supreme Court reversed the Federal Circuit, which it's been doing a lot lately. And so that's an interesting aspect of this.
There's some legalese here. I just want to make it clear to everybody. En banc means we go from the 3 judges that were in.
To all the judges that are sitting on the Federal Circuit.
Okay.
And then, you know, you can petition the Supreme Court to take the case. It doesn't take that many cases, but it's been taking a lot of cases by this particular Court of Appeals, the Court of Appeals for the Federal Circuit, and in almost every one of the cases they reverse. So that's been an interesting thing, although at least at one level, there are issues in this case that are similar to the issues in a case, Lotus v. Borland, where the Supreme Court split 4-4 back in 1995, I think it was, or 6. So it's possible that the Supreme Court will also be interested in taking the case because they didn't resolve the Lotus v. Borland issue back then. So those are some of the options, and of course it's possible also to settle, although I'm not really expecting that in this case.
Fair use. When I think API, I think, okay, that's like one line of code, right? To me, it's the call that you make that invokes a whole bunch of other, that, you know, APIs are designed to obscure a whole bunch of other stuff, right? And we heard yesterday from various API providers that the amount of complexity they obscure behind one API is significant. But it's all in one line.
Complexity has nothing to do with
copyrightability
or fair use or any of the other.
Well, what I'm getting at is if you make a call to that complex function with one line of code, and I think about what fair use has meant to me as a journalist over many years, there's like, okay, depending on where you work as a journalist, you can take 10% of the text of somebody else's article and incorporate into yours, as long as you give credit. 15, 5, there's an argument over what it really is. Nobody, unless you copy the whole thing, nobody really makes a stink about it. But if it's just one line of code, can the same rules, what is fair use of an API?
It's an aside question you're asking. There's 6,000 lines of code.
7,000.
7,000 lines of code. So let's not
argue
about whether a bubble sort is copyrightable.
Well, part of the reason I'm asking this question is because in the web API world, they're a little bit different from Java APIs. This is the way web APIs work.
The analysis of fair use looks at the work and looks at the use of the work and looks at how it was intended to be used and what the effect is of that so-called fair use. So independent of whether it's 7,000 lines of code or 7 million lines of code, depends on what the uses are. And here's the analysis. You're supposed to, there are 4 factors for fair use. The purpose and character of the use. Well, if we define the use as a specification for people to implement software, then the purpose and character of the use is exactly what Sun and Oracle wanted. If we say the second factor, the nature of the copyrighted work, it is an API, it is a spec. And if we treat the nature of the work as being not 7,000 lines of software, but rather instructions for how to write software, even though it has code in it, then it would seem to me that the nature of the copyrighted work is such that the fair use factor would be in our favor, or Google's favor in this case. The amount and substantiality of the portion used, that's the third factor. And quite frankly, they used it all, right? Most
well,
of it.
they used 37 of 160 packages.
30, okay, but they were supposed to. They
No.
were told, make it compatible. And the final factor is the effect on the potential market. How in the world is Sun hurt or Oracle hurt by having more people write APIs in Java? In fact, that's what they want. Write once, run anywhere.
All right, go ahead.
So this is a great discussion. Okay, so engineers especially and journalists and everybody wants a percentage that counts as fair use. David, I totally hear you, right? Documentarians, everybody always wants.
We just want to
guide. There's the 10% rule of thumb.
We just want a guideline so we know we're not going to get sued.
All right, so here's your guideline. A private non-commercial use is almost always going to be fair, okay? That's why, in another case I'm working on right now for Dish, we're making the world safe for commercial skipping on your DVRs, If you're doing it in the privacy of your own home for non-commercial reasons, Sony and other cases say it's going to be fair, right? But when you're doing it for commercial purposes, and you're harming the markets or the incipient markets or the potential markets for the original work, that's the definition of unfair. That's the very definition of an unfair use, all right? So when we ask about the purpose and character of the use, that's right, that's the first factor. The single most important aspect of that is whether the use was commercial or not. And of course it was commercial here. Of course it was a commercial use. So develop a commercial application to be sold in order to maintain and improve Google's position in mobile search. Its purpose could not have been more commercial. I'm going to focus on two of the factors. The fourth factor and the first factor, that's the first factor. The fourth factor is those are the two most important factors. The fourth factor is whether the use harms the market for the original or its derivatives. Before Android, we had licenses, there were licenses from Sun or Oracle to BlackBerry, Kindle, variety of other commercial applications, including in the smartphone or feature phone and tablet space. Now, none. By definition, all those things that have moved over to Android that were once using the Java platform to develop those applications are the kind of harm that historically has always been considered unfair in the fair use analysis. Now, the answer that many of my colleagues on the other side have offered is, well, interoperability, we need interoperability for fair use. And certainly those are the cases to which Professor Samuelson referred, the Sega and Sony cases where the courts held that interoperability was an important factor. So what do we have here? We don't have interoperability. Android's not backwards compatible with the Java platform. Those applications don't work with each other. So even if interoperability were an important factor where you have a commercial purpose and you've destroyed the market for the original work, it's not present here as a factual matter.
Okay, you referred to the difference earlier, or the lack of differences between the case where Sun sued Microsoft and Oracle sued Google.
I say what was at stake
was
similar in both cases.
Similar, but maybe I have the timing wrong. But if I recall, that at the time that Sun sued Microsoft, Java was not open sourced. But at the time that Oracle sued Google, Jonathan Schwartz, by that point, who was the former CEO of Sun, had led a very painful effort inside of Sun, hotly contested and debated to open source Java. At which point, did that not make the fork that Google created both legal and feasible so long as they contributed their code back to the open source community?
At any time, Google could have agreed to take a license on the terms for which others were offered license, which the key element of which is not present here, is compatibility. Mm-hmm. And that was the key element at stake in Sun versus Microsoft as well. If you read the early opinions, there was an injunction granted, and the key element of the license offered in that case that was not met was compatibility.
But did Sun give up, or when Sun open sourced?
Did it give its right to insist on compatibility? No. Because when you license, you can put conditions into the license, and it's a common and basic condition in open source licensing that you give the code back that you create that's based on and part of the underlying open source code. And if you think about it economically, that's the only way open source can really work. Otherwise, people are always giving everything away for free without any prospect of return, even in a services economy. Those improvements come back.
Larry,
or you pay for it. You
careful
pay for the right not to give them back.
I just say be careful what you say, Larry, because I noticed you cut, she could
She
completely rip that wound
I
open
didn't
on
do
you.
She didn't. There are some factual problems here that I want to clarify.
And then I want to get a word in it.
Yeah, absolutely.
The
Poor
Apache
Mike here. We'll
software-
get to him soon enough. Don't worry.
The Apache Software Foundation was a part of the Java community process, which was supposed to be an open industry standard with lots of participants from lots of companies to develop the Java specification. When Oracle took over, actually prior to that, when Sun was still involved directly, Apache withdrew from the Java community process over this exact same point. The notion that you take a specification and then impose licenses on it that prohibit the development and release of open source software is no longer acceptable in the software industry. So requiring compatibility is anathema to the open source rules. You cannot impose a compatibility requirement on open source software and have it be open source. You cannot.
Yeah. Pam?
So there isn't a fair use case out there like this one, for sure. I think that one of the things that will be interesting to see is how courts grapple with this. I think there's another point of view than the one that Annette just gave us about how fair use might be viewed in this situation. I think the commerciality of a use is something to be taken into account. But these days, whether the use is transformative is probably much more important than whether or not it's commercial. And I think that there's a reasonable argument that re-implementation of the Java APIs in the Android software is a transformative use within the meaning that the courts have given it. Under the Sega case, which we've mentioned before, which is a Ninth Circuit Court of Appeals case, the nature of the work is software, and software is functional, and that means that it has a thinner scope of protection from copyright law than other kinds of works. As to the amount taken, the courts lately have been saying that how much you take has to be reasonable in light of your purpose. And I think that, again, reasonable in light of your purpose is to re-implement the API so that people can write applications for it. How exactly the harm factor would play into this, I'm not sure. But what I can say is that there isn't a fair use case out there just like this one, so that it will break some new ground, whatever happens, if if the issue goes back to the trial court again. It's also worth mentioning that when a jury heard this case a couple of years ago now, the jury was within one vote of saying that Google had made a fair use. So it's a plausible fair use case if the jury almost prevailed on that issue back at the time that the case was tried. So.
Thanks, Pam. One of the issues that I'm particularly concerned about, and I'm sure others share this concern, is events like this, APICon, our site, Programmable Web, many other sites. We're all racing towards a world that's based on certain best practices. And what I mean by that is we all are together as a community recognizing that there are certain patterns emerging in terms of how APIs should be designed, made really easy to use for developers, taking all the friction out. You know, from one API to the next, it's going to be very predictable. Companies are building huge technologies that essentially bake these patterns into the technology in a way that the technology produces an API that will often be a repeat of the last API it created. Does this just completely wipe out all of that work? If one pattern can be copyrighted, it may not be, and the copyright holder chooses to protect that pattern, well then we can't repeat the production of that pattern, repeat our best practices, and then what ends up happening is we design APIs to work around the copyright, and we end up at a place of friction that inhibits the growth of the industry and inhibits developer access to those API, frictionless access to those APIs. What do we do now?
I just like to say again, in W3C, when the HTML5 specification was written, they purposely chose a new way of writing specifications so that it was both code and spec simultaneously. And in fact,
and that was a deliberate choice because of these issues?
Because of these issues. They want to make sure that when people implement, they know how to implement. And the best way to describe how to implement is to implement, which is why in ITF, for example, one of the things that they like to see is an open source implementation of their specification in order to at least prove that it can be done so that anyone else can write whatever they want. So the notion that you have a specification that can be written in an open source program is critical for specifications nowadays. I don't know of any standards organization that avoids open source implementations. And in order to be open source, you have to be able to fork it. You have to be able to implement it. And you cannot charge royalties for it. And so there's a conflict in the mind of at least one company about what their goals are.
How can you enforce the obligation not to charge royalties for it without copyright?
If those royalties are material to Oracle, I'd like to know that.
No, that's not. I'm responding to your point. You can't. The fundamental definition of open source is you can't charge royalties for it. But without copyright,
that isn't what I said. That isn't what I said.
Oh, I misunderstood you.
The person who develops the specification cannot charge royalties for the specification. Anyone who writes open source software can charge whatever they want. But once they give it away or once they sell it, it's under an open source license. And that person can change it. So why did Apache withdraw from the Java community process? Not because we didn't want to implement exactly the specification. We want to. But because downstream, the open source community that uses our software, they must be free under the Apache license to do any damn thing they want. And that's the reason that the restrictions on an open standard that require the payment of royalties or a patent license or that contain encumbrances and restrictions on what kinds of applications you can write. For example, Sun saying you can't write applications for kiosks, which is one of the restrictions in their little license that they try to sell to people. Well, that's not a restriction that open source can live with. We just can't.
So standard setting is a different process. And normally when you have an official standard, you have license terms that go with that are different from something that is not an official standard.
Correct.
And the Java platform is not an official standard.
News to me. What in the hell is the Java community process?
Well, it is true, though, that Sun, and I'm sure Oracle, they're sort of the host of the JCP, Java Community Process. But it's not a de jure standard along the lines of something that comes from the W3C.
It's not ANSI, it's not NIST, it's not any of these things.
Who cares?
Who cares? Well.
All right, so I want to, a lot of open source talk. The decisions have been made. Let's say things go along and it ends up being copyrightable. There's a lot of people in this room who are reusing patterns like I just described, or maybe have their own pattern. Now they have to do something. Or maybe they can wait because it's going to take a while to play out. But we have some choices here. I want to give Mike, you've been quiet the whole time, I want to give you an opportunity to talk about, it's been proposed that, by another company in the industry, 3Scale, that we have an API Commons. It seems to me that probably the world doesn't need multiple commons regimes for different industries, that if we can serve the purposes of multiple industries through one commons regime, that would be great. First of all, is a commons applicable here? And is that commons Creative Commons?
Well, commons is generally applicable. We say we want to create a commons, which is generally, a set of resources that there's shared access and responsibility for. So you can think of a lot of different things as commons. I think it's a great metaphor, and you can apply the commons metaphor at different levels here. One that you're talking about with API Commons, which is a website directory of APIs, and Programmable Web also has a directory of APIs. I actually mentioned those in my different things around APIs as API metadata or API registries, API direct. So those things are sort of separate from the terms under which APIs are available or what the default regimes are available for implementing APIs. But things that are central points for community to look at, like directories, can help set the norms for community. And so to the extent that Programmable Web Directory or the API Commons Directory is encouraging a particular set of licenses for the different sorts of materials that can comprise an API, then that can be helpful or not. And can briefly review the options. Oh, and actually, a discussion of standards bodies actually is one. Actually, submitting your API to a standards process is an option, and that will involve granting rights to other people to implement that specification. There's also lighter weight versions of that. The W3C now has a community group process where you can take advantage of the same kind of legal affordances, but not actually go through the full W3C process. It's very easy to start up. Another lightweight one is Open Web Foundation that Larry's involved in, and he can, that also kind of allows you to obtain a standards-like process, but without all the traditional heavyweight. Then there are public licenses, open source and Creative Commons licenses, which are typically copyright first licenses and apply to individual programs and works, but you can apply them to things like specifications, reference implementations, etc. And in general, I would suggest using an open source license, actually not a Creative Commons license. Apache license is the most obvious one. It's a permissive license, doesn't impose any conditions other than copyright notice and a patent grant. And that patent grant is actually quite important because copyright is not the only threats around implementing APIs. And that actually gets to, there are a bunch of kind of theoretical misunderstandings about open source that you really should, and that's been promulgating, that you really should not go away from this panel, but I don't think there's time to dismiss all of them. But just everything she said about open source is wrong. And then there's Creative Commons licenses, and I don't suggest using those. Creative Commons doesn't recommend using them for software, and although there can be a documentation component, it's easier to use the same license for everything. Apache license is a good option. The reason for not recommending Creative Commons licenses for software are basically that they're not designed to be compatible with other open source software licenses, and if you want implementations, you want to be compatible with those licenses. They don't have patent grants, or one of them has an explicit patent exclusion, so there could be landmines downstream. And there's just a general understanding of using open source licenses for software-like stuff. So if you don't want to think about it at all, and you probably shouldn't, just use the Apache license.
So today, if the people in the room are most interested in protecting their interests moving forward, and for the time being, the court has ruled that APIs are essentially copyrightable, should everybody in this room be racing to protect their, if only for defensive reasons, to make sure they don't get sued, should they be racing to copyright their APIs, put an open source license on them, and just get their legal house in order to ensure, again, mainly for defensive purposes, because I think a lot of the people, a lot of the members of the API economy, if you want to call it stakeholders, are not interested in copywriting their APIs for offensive purposes. Should they act now and get something done?
Everybody in this room already is. I mean, so 2 weeks ago when you asked me to participate in this panel, I went to Programmable Web. There's, you know, you can look at the top APIs of the day, right? I clicked through on the first 10, and every single one of them had terms of use on their websites describing both their sites and their APIs as copyrightable subject matter in which they claimed an interest. Every single one of them.
I want to thank you, by the way. That we were wondering who the source of all that traffic was in that particular day.
So
I think
so,
that's
you know,
right. Everyone does.
Everyone does. Everybody's claiming copy. There's not this cultural phenomenon of no copyright here. Quite the opposite. If you just look how people are actually behaving in terms of the way they're labeling things.
But legally, putting a copyright notice on something doesn't prove much. It certainly isn't the end-all for a copyright case.
It's not necessary at all for protection for copyright anymore. The copyright either exists or it doesn't from the moment you create.
But there's a conversation to be had internally about what this means, and you know, what should we have ready in the event that somebody comes and sues us or something like that.
Well, I hope you're not asking those of us who are attorneys up here to give legal advice to the people down there. That ain't going to happen unless you give me a check.
Somebody had to make that disclaimer sooner or later.
Yeah, you know, no one here is going to give you permission to do anything other than to say, I will tell you what Apache is doing, for example, which is giving the middle finger to Oracle with respect to the Java community project.
I'm glad we got that clear. I hadn't noticed.
Be careful, Larry. That wound's going to get ripped open in a minute, I can tell you.
Read the JCP formation documents to see what Java was intended to be. But in fact, we're proceeding. But with respect to implementing big projects in Java, quite frankly, Sun and Oracle have cut their nose to spite their face. There are a lot of people in Apache who are no longer using Java.
Can I get a question from you? We are flat out of time. Obviously this has been such a heated debate topic, and it's hard to kind of turn it off, but I do want to get at least a question from the audience. How about right here?
So there's this concept called a clean room development, where you recode to implement an API.
Start again, please.
It's a concept called a clean room development, where you recode to implement an API. And my question to the panel is, if the decision stands, do you think it's possible to still do that?
Anybody want to tackle that one?
So I think yes. I think that the likelihood is that anyone who tries to extract interface information and then re-implement it is less likely to run a risk of being viewed as an infringer. And there are certainly cases where people have done clean rooms that are still valid precedents for re-implementation. So I think that that's still something to say it is a good thing to do. I think that it's quite likely that even if this appellate court decision stands, that courts will distinguish the kind of clean room situation from the Oracle v. Google case. And the dicta, so one of the things that actually lawyers pay a lot of attention to is what's the holding and what's the dicta. And courts often say, when confronted with this statement and this statement and this statement from a decision, that's dicta. That means it's not really binding. And so I think that there's, again, a lot of room for interpretation. I think one of the things that Annette said at the very beginning that I very much agree with, which is APIs are not all one thing. And so it's a very broad category. So I think it's a mistake, even if you think that the Court of Appeals was right in this particular instance. It doesn't mean that all APIs are automatically as protected by copyright law as the Judge O'Malley's decision made it seem like they are. And so, but I think the sort of the distinction between the specification and an implementation is one that's going to continue to be important, so that even if a specification document might be copyright protectable, re-implementing the specification in code, I think is still going to either be a fair use or something that simply doesn't infringe the copyright.
Pam, thanks very much. I really want to thank everybody for coming up today. It could have turned into a slugfest. I think everybody kept their cool, and it was a really well discussed topic. So thank you for coming out this early this morning to talk about this. And thank you for responding to my invitation so late in the process and coming out here on such short notice. Thank you very much. Please give our panel a round of applause.